All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time and date set for oral argument in cause number CV19 0810 Carol Bellemare versus Lemon Law Group Partners. These proceedings are being audio and video recorded as well as live streamed, so we ask you to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes to argue. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal should you choose. Also, we've read the briefs, we've conferenced this case, we are familiar with the facts. At this point, counsel, a little tongue-tied this morning, you may proceed, but first, if you want to take your masks off during your argument, we ask that you do so. You're 6 feet away from everybody, so you should be safe. Additionally, we ask you to argue from a seated position so that we can get the microphone transmission picked up, so when we live stream it, you'll be able to hear it. So those are the two additional things I'd like to point out to you at this point, counsel. When you are ready, please proceed.
Thank you, Your Honor. May it please the court, I'm Ross Meyer on behalf of Lemon Law Group from Will and Check and Partners. First off, thank you for scheduling this oral argument so quickly, despite all the circumstances going on around our state and the globe. I wanted to note first off that in writing this briefing, it truly felt like a case more like an Anders appeal rather than traditional appeals that this court sees, just because there's so many issues before the court that do create reversible error. I wanted to walk through three main points today. The briefing goes into it, numerous others, and I'm happy to take any questions from your honors, obviously. And those three main points are: the jury instructions in this matter completely avoided the underlying Lemon Law case. Typically and expectedly in a legal negligence case, you need to get to the case within the case, and what would the jury have done in that matter. Here, that's completely devoid from the jury instructions that were given. Second, I want to touch on the damages in this case. There's a few issues there. Number one, the plaintiff did not point out how she was damaged by Lemon Law's actions or inactions in this case. Specifically, after the termination date that everyone agrees upon, at least that was the latest date, there were still 6 months to file any type of action, to contact any attorney, to seek her arbitration claim. Instead, she settled for the same amount that Lemon Law Group obtained for her earlier.
In that regard, Mr. Meyer, did the firm specifically advise her of the date that the statute would run, the 2 years and 6 months, if that's your theory?
No, Your Honor. The record does not indicate that it was specifically advised. What did occur...
I mean, isn't that a problem?
I don't believe so, because advising the client that you need to understand your statute of limitations and call us if you have any questions, which is what was communicated, that indicates that the case is still live. So that would put the onus on, look, we need to figure this out.
Is that really a best practice that your firm would engage in?
I don't believe it's a best practice, but it's...
Isn't it pretty much implied by ER 1.16 that you need to take measures to make the end of the attorney-client relationship as non-prejudicial as possible?
I don't believe so, Judge Swan, specifically because at the termination, the plaintiff was provided with all of the arbitration papers that could be filed, knew who the contact information was, and knew that there was still time, at least, to file that action, which is why she did go and settle with Porsche eventually. That's what happened. It's not like she knew that she couldn't settle with them. If Porsche knew, obviously they're involved in this type of litigation, if the statute of limitations had run, there would have been no settlement. And that's exactly why she went to engage in those settlement discussions.
Wasn't the $8,000 characterized as a goodwill gesture by Porsche? I mean, you don't need to be on the hook for liability to satisfy your customers.
Porsche released Ms. Bellemare released all of her liability against Porsche related to the vehicle in that settlement. So yes, it may have been characterized by Porsche in their original letter as a goodwill offer and gesture for being a customer.
But you're saying the record clearly indicates that everybody knew there was a potential live claim out there and they compromised it.
I would not go that far to say the record states that, but I would say the actions demonstrate that, and that the settlement was made 6 months after,
But
or
when-
5 months after the termination.
When we look at what she was aware of, and if she in fact thought the statute had run, why wouldn't she accept anything they were willing to give her at that point? I mean, you're arguing there's an inference that she knew that the statute was going to run a month from when she accepted the settlement, but isn't the converse also true?
I guess the converse could be true, but this exact discussion gets into the prejudice that Lemon Law suffered from not being able to have Mr. Harvey testify at trial. Mr. Harvey was Ms. Bellamare's boyfriend, went to law school, was the one advising her behind the scenes of what to do and what steps to take. And that evidence of what she knew would have been very valuable to the defendants in this action.
And Mr. Meyer, I just want to circle back to my original question and make sure I understand. It's your position that either the ethical rules or the standard of care does not require an attorney, upon terminating the attorney-client relationship with a pending claim, to advise the client as to the statute of limitations that applies to that claim.
My answer to that is, in this matter, and I'm not trying to avoid your question, so if I don't answer it specifically, I will come back to that. But in this matter, it was the defendant's position that Ms. Bellemare terminated the representation.
Does that really matter? It's the relationship is terminated. There's an obligation upon termination created by the ethical rules. And I'm just trying to figure out whether what you're saying is those ethical rules and or the standard of care does not require that law firm upon termination with an open claim to identify for the client when the statute of limitations expires on that unfiled claim.
I think it would have been a best practice in this matter, but I think what was said in the September 14th letter met the ethical standards of indicating we're available at any time to discuss any options you want to take or questions you may have, and there are statute of limitations that you should be aware of and determine. The reason for that is because during the representation there were questions as to whether California law was going to apply to this claim or Arizona law was going to apply to this claim. And I understand your premise in that, well, both of those should have been advised. But I believe under this, Ms. Bellemare knew that she still had a live claim and that she still had time. And she could contact my clients at any point to determine that.
I want to switch subjects for a moment from the merits of the case to the manner in which the case was tried. And I want to give both sides a chance to address this, although I suspect I know your answer. Is it your position that the trial judge completely missed the case within a case structure of a legal malpractice case at trial, or did something else occur?
That's our position, is that it was completely missed. And where you see that on the record, and in my rebuttal, I can point you to the exact Penn site, but the local judge or Superior Court judge indicated when this was presented, when the jury instructions were requested, she said, I think that's going to confuse the jury, and this isn't a lemon law case. And the response from us was obviously, well, it is a lemon law case. And that's necessary to prove an illegal negligence action, is that you have to prove the underlying action.
Okay.
I'd like to go to the damages secondly, in that, checking my time. With regard to damages, there's 2 points that need to be shown. One, that Lemon Law Group caused her damages, and secondly, what her damages would have been in the underlying action. By settling this case afterwards and having that time to settle the case, it's difficult, if not impossible, to see where the damage was and what it was resulting from. The plaintiff at trial alleged that the damages stemmed from Lemon Law Group not filing the action. However, that's not a but-for proposition of that. There was still time to take that action, and in fact, she settled and resolved the underlying claims. Secondly, with regard to what her damages would have been in the underlying action, the Arizona statutes are clear. It's either a new vehicle that the dealership will replace, so a replacement vehicle, or the cost of the vehicle when it was purchased minus reasonable use. Here, at trial, at this trial at least, Ms. Bellemare no longer had the vehicle. That's a question of law and whether that's necessary in a malpractice action. But at least in the case within a case, if she went up against Porsche and did not have the vehicle, she would have no damages. Second, she sold the vehicle for $35,000 after it had 51,000 miles. At trial, there was no evidence of what the reasonable use of that would be to be able to calculate those damages, and there was no instruction as to what those damages would have been under the statute. So here it's difficult to see how, if you take those numbers and assume that the reasonable use was valued at zero, it's about a $35,000, $38,566 would be the max damages. And here the jury awarded $80,000. So that to our clients on appeal is a very clear failure by the jury to be instructed properly on damages. Excuse me, my throat is very dry. Lastly, on the breach of contract, here there's no specific clause within the contract that is breached. The clause that's alleged, again, is the not filing a claim in arbitration. However, that's a negligence action rather than a breach of contract claim. And for that reason, it appears that's why the jury awarded allocated fault in this action, which isn't appropriate under a breach of contract claim. So to us on the record and looking at that, it's not clear that the jury entered a verdict on the breach of contract action.
So, Mr. Miser, are you saying that a breach of contract should have been off the table and the verdicts rendered by the jury were solely in regard to the negligence claim?
That's our position, is that the jury's verdict was in regard only to the negligence claim because of the allocation of fault in the jury verdict. And two, in the event there was a breach of contract finding, there were numerous elements of breach of contract that were not present. Number one, a specific clause in the contract that was breached, and two, damages. And if there's no other further questions, I'll reserve my remaining time.
Thank you, Mr. Meyer. When you are ready.
No, if it pleases the court, I'm Joseph Taboni. I represent Carol Bellemare. One pattern that has defined this entire case, starting from when Ms. Bellemare signed on with LLGP, all the way to post-trial motions in Maricopa County was that defendant did not take actions at the appropriate time. And our position is that when a party or an attorney misses the key deadlines and either does nothing or attempts after the fact to repair it and say, okay, well, we meant to do this, the attorney bears the risk that every inference, every judgment call in the world can go against them. And that here in the Court of Appeals, the standard would be something like manifest injustice for fundamental error. That's where you would reverse if the arguments that the attorney failed to oppose in the trial court or opposed untimely, that's the only position, that's the only way you could reverse them.
Are you saying that if the trial judge made errors of law, we can't reverse on that basis?
If they were complete 100% errors of law, then yes, you would have to reverse it. But if
Well, let's start there. It seems to me that the trial court unfortunately disregarded the entire structure of a legal malpractice case and refused to allow case within a case even to be tried. Does that not count as an error of law?
In this case, no, because the jury instruction has to be supported.
Forget the jury instruction. Before you get to the jury instructions, you've got to have evidence, and she wouldn't allow evidence to be presented on the case within the case. So how is the trial not fundamentally flawed from that point forward?
I believe the record will show defendant declined to discover or present evidence of the case within a case. They conducted
Can you
no
cite the
discovery.
record for that proposition? Because that's not my impression of the record. If you're correct about that, it would be important. Do you have a record cite?
I guess I would be citing the entire trial transcript for
It's not much of a cite.
for the notion that they did not.
I mean, there should be a moment. I mean, the defense offered the evidence, the trial court rejected it. There should be a moment then when the defense said, oh yeah, you're right, we didn't want to prove that at all. But I don't detect that either from argument today or from our review of the record.
Defense made some passing comments in the defendant's closing argument. They said the fact that Portia offered $8,000 is not dispositive that the plaintiff in fact had a lemon.
Mr.
That's not what
Giovanni, whether or not the defense did or did not offer evidence, wasn't it your burden on behalf of the plaintiff to present evidence not only as to the alleged malpractice, but as to the underlying case, that but for the alleged malpractice, your client would have prevailed on the merits in her lemon law claim? Wasn't that your burden?
Yes, it was our burden.
Okay, so it really doesn't have anything to do with whether or not the defense did or did not offer that evidence. It has to do with whether the plaintiff offered that evidence or argued to the judge that it should be accepted. Now, tell us about that.
Yes, thank you. The plaintiff on the witness stand testified to a prima facie case that her car was a qualifying lemon under Arizona law. She told the jury that it had been out of service for 40 days in the first 2 years. And the jury was made aware that the presumption in Arizona is 30 days out of service. And she told them about how she went to the dealership and all she saw her car scattered across the maintenance floor and so forth. So that is the evidence. It wasn't strong evidence because defendant was able to get her maintenance records exclusive.
Yeah, it's pretty weak evidence, and I think the defense picked up on that and moved for judgment as a matter of law, and then the trial court's response was, that's not even our case. So if the trial court is unwilling to evaluate the strength of the evidence that you just mentioned, to determine whether there was some way the jury could find that your client would have won the underlying Lemon Law case, isn't this whole malpractice trial just shot at that point? Because the trial court has failed to apply the correct legal structure?
Well, there would still be the breach of contract claim, and I think the
Well,
trial
you can't, you'd need a new trial on that, it seems, because the breach of contract verdict came coupled with comparative fault, which has no bearing on a breach of contract claim. So how do we even know what the jury decided?
I think it was apparent because the defendant presented no evidence, and there is, quite frankly, there is no evidence that this vehicle did not qualify as a lemon under Arizona or the federal lemon law.
Well, evidence that it did not qualify isn't really what's before us, right? We're concerned about, as Judge Winthrop said, the evidence that it did qualify. And you acknowledged, despite the fairly colorful picture of parts being strewn all over a shop floor, you acknowledged that the evidence of this car being a lemon is on the edge. And that is what the motion that defense filed was designed to have evaluated, and the trial court simply declined. Am I misunderstanding the record?
I would, Your Honor, I would not concede it was on the edge. I would say, while it's the car owner's direct witness testimony, there's no precedent in Arizona lemon law that states there that is insufficient. I know very recently there was a major lemon law case involving noisy brakes, of which the key evidence was the driver testifying that the brakes were noisy on his BMW, Nordine versus BMW. So I believe the plaintiff in this case provided the jury with enough information to conclude that there was a qualifying lemon. And, I should also mention another bit of evidence was that all of defendants' correspondence with Porsche indicates they thought it was a lemon too, and that went into the record, and the jury was able to hear it from defendants' own words. One of the key paragraphs was in their defendant lemon law group partners told Porsche, this vehicle is a lemon because it spent more than 30 days out of service.
Don't they tell every manufacturer their car is a lemon? I mean, if you start a law firm called Lemon Law Group, you're probably taking that position a lot. That's not really evidence that the car was a lemon.
And they had, at least according to their website, they are experts in lemon law.
Well,
and yet
that's great, but
they
that's
didn't
not,
present.
that has nothing to do with anything this court can consider. That what they advertise as to their expertise has no bearing on her likelihood of success in a case within a case that the Superior Court failed to consider.
It's the absence of a defense that I'm asking you to consider, that they didn't bring any of their own experts.
Yeah, but
already
unfortunately
to testify.
for your client, our system of justice requires the plaintiff to meet the burden first. The absence of a defense is irrelevant.
It would be, since it's a civil, lemon law is a civil claim, it would be the preponderance of
I'm
the
aware of that.
evidence.
Yeah.
Yes. And the trial court could not have abused its discretion in allowing that evidence because all the evidence, even though small, was uncontroverted.
Well, I don't think the question really focuses on an evidentiary ruling. The question focuses on a ruling on a motion for judgment as a matter of law, which the trial court essentially declined to do because it seems to have misperceived the very structure of the case. And that may not be plaintiff's fault, but it does appear to be a credible allegation of error that we need to dig into.
And I was, from the start, I said I believe you can uphold the ruling if it is correct for any reason. And in this case, we have the plaintiff's testimony, defendant's own testimony before they became malpractice defendants. And in light of the complete record, if this case is reversed and sent back down to the trial court for, let's say, okay, a lemon law case within a case trial, the plaintiff then will file a motion for summary judgment saying to declare that this Porsche Cayenne was a lemon under Arizona law, and it will be granted.
I think that's a leap, but part of that case within a case, Porsche repaired the car, and part of what she'd have to prove is the repairs were unsuccessful. We don't have anything in the record to prove that the problems persisted other than her statement to that effect. But we also have a circumstantial issue where she sold this lemon to another party with representations that it was working. So explain how we're supposed to derive from this record that the repairs were unsuccessful. She drove it 51,000 miles.
The trade-in of the subject vehicle happened after she had already settled with Porsche. So I don't see the logic of the causation argument appellant is making. So you're asking, does the trade-in value of the subject vehicle negate the reality that it was a lemon or that it qualified under Arizona lemon law? Again, an expert in vehicles could have taken the stand and said, well, this is how much, it's an expensive car, this is how much its parts are worth if it's scrapped and sold for spare parts. This is the reasonable use of the value of the reasonable use of the vehicle for this many miles. This is what legal fees would have been collected in a lemon law case. But they declined to do that.
Who declined to do what?
Lemon law partners declined to argue or present any of those issues in the trial court.
Well, Mr. Tavoni, putting aside the fact that the judge apparently decided to omit this type of evidence, were you prepared to put on evidence that the car was defective under Arizona's lemon law? Had you listed any of the repair technicians to testify? Had you identified an expert to testify about the quality or lack of quality of the repairs and the value of the car? Were they listed as witnesses in the pretrial statement?
No, and I'll tell you why. Again, in the pretrial statement, they did not declare any controverting evidence to the lemon status of the car.
Was it an uncontested fact deemed material by the parties?
In their list of issues, they named it as an issue, but they did not back that issue with any evidence. And again, I want to also add that after the joint pretrial statement in the final trial management conference, a week after the JPTS was in, the court asked the parties, in 1 week, I want your issues and claims to be proven and made to be proven. And again, when we submitted it 1 week later on July 19th to the court, no mention of case within a case, no mention that they're going to defend, that they're going to step into the shoes of manufacturer and defend the lemon law.
Mr. Tavoni, I think you're misunderstanding the
Might be.
obligations of plaintiff's counsel in these types of cases. It's not, whether or not the defense was prepared to address those issues, we're really asking whether you were.
Yeah, I was absolutely prepared to take those actions and track down the maintenance person if defendant had mounted a defense to the case.
This has nothing to do with the defense. It's your job when you walk into court on a legal malpractice case to prove the case within the case. That's just your job on day one. The defense could not show up and you still have to prove that. So what is the evidence here that proves that?
It's the direct testimony from the plaintiff and
the direct testimony from the
documents.
plaintiff seems to morph over time. At one point, she's got this $80,000 oil leak, but then by the end, the car is a lemon because it hesitates and she doesn't like the way it drives. That's pretty slim to establish that a car is a lemon.
I believe you'll find in the day one testimony that's after the 3 separate trips to the maintenance center totaling over 43 days. After that, then the car is running, but it's not. It was still.
She doesn't
running
like
with
it.
Imperfect. It was still running with.
Did she identify a single defect in the car after the 43 days, or just her own subjective opinion that it wasn't an ideal driving experience for her?
I don't recall if she.
Well, what was wrong with the car?
Fine.
What part was broken on the car after the 43 days? What didn't work?
I believe she stated it was generally unreliable and would sometimes overheat. But at that point,
You can't expect to win a legal malpractice case based on somebody's general allegation that something is generally unreliable. I mean, there's got to be something.
well, it's already past the 30-day threshold under the Arizona lemon law statute at that point.
So you're saying on day 31, a manufacturer suddenly becomes liable, and that's just that. I have a feeling that if the Lemon Law Group agreed with you on that, they would have handled the case differently. I think that may be a bit of an oversimplified abstraction of the presumptions under the Lemon Law.
I believe the statute says it is presumed that a reasonable number of attempts have been made if it's out of service for 30 days in the first.
So they wind up giving her a new engine,
and if
right?
Yes, and if
whole new engine, and then she says it's generally unreliable.
She's met the presumption that a reasonable number of repair attempts have been made, and if in a lemon law case, it would then be on the manufacturer to rebut the presumption. Again, with the defending of the case within the case, if
Which
they
goes
chose
back
to
to
do
my
it.
question. Wasn't she required to prove the repairs were unsuccessful as well? You're saying if it's more than 30 days, it's an automatic lemon, there's nothing you can do, the manufacturer has to rebut it. What would be the onus on the manufacturer to continue to try and repair the vehicle or make the owner happy with the vehicle if that were in fact the standard?
Customer relations, as they said, a goodwill offer. Not every car owner will immediately go to the lemon law courts because once it hits the 30-day threshold. And plus the service center, that's what they do. They repair cars. They're not lawyers, so to speak. Does that answer your question?
If, in fact, you did not have the requirement on the person claiming the car was a lemon to prove that the repairs did not remedy the problem, if you don't have that, because 30 days it's been out of service, once it's been out of service 30 days, all manufacturers would take the car back and give a replacement car, if that were the law, would they not?
I believe they would negotiate with the car owner, and perhaps if they're quite generous, say these are your rights, but we can fix your cars. And it was 40 days with this automobile, so we have a comfortable safety margin lemon law presumption.
And time has run. Thank you, counsel.
Thank you, Your Honor.
Thank you, Your Honors. I want to touch on a few points first. Number one, with regard to the evidence presented that the case within a case would fail by the defendants. One aspect is in our appendix 795 through 804. It's in trial day 2, starting at page 36. And that's where we're focusing on what her damages were and whether she had damages and the fact that she traded in the vehicle. And so that evidence is where we put on that within a case, she had already sold the vehicle, that she had driven it 51,000 miles, and showing that there's very limited damages here after she's owned the vehicle for almost 4 years, a few months short. Secondly, I wanted to indicate where the judge, I said earlier, I'd tell you the site for where the judge was indicating that she did not believe this was a lemon law case. That site is at page 910 in the appendix, lines 3 through 5, just so that that's on the record. Secondly, I want to get to, you're right, an error of law does constitute an abuse of discretion. That's cited in our briefing. It's State v. Bernstein, 237 Arizona 226, and a few other cases that we did a string cite of, making that point. And obviously, not providing the jury with the correct law would be an error of law because there's no law that could be correct on that issue. The next point I'd like to get to is we have not found that the continuing defect that was ongoing with the vehicle. Instead, there was evidence that Ms. Bellemare continued to drive the vehicle. It was not going back for service for the same issue repeatedly. And yes, while it was in the shop for a number of days and that was presented.
Let's talk about the number of days.
Mm-hmm.
If, in fact, it is, as your opponent argues, that if your vehicle is in the service center for 30 days, it's automatically qualifying as a lemon. Is that the way you understand the statute?
I don't think so. I think what the statute says is that it's a presumption, and that makes sense. But that presumption can be refuted if the vehicle works, if it's used, if it's not having the same continuous defect. And that would be our take of it. As the point, I bought a car last night and made sure I got the warranty just so that I would make sure that I have all of those aspects. But that's the point of the statute, is to create a presumption, obviously, for consumers, so that it's not so that there's a path forward on these type of cases for the judge and the finder of fact to determine. But it's by no means conclusive. If once you hit the 30 days, it's a done deal and you get a replacement or all your money back. I mean, that would significantly change the liability in these type of cases, and it would provide the manufacturer no incentive to fix the vehicle on that 31st day. I mean, if the car were sitting in the shop while they're waiting for a part to get fixed, and if the post office is delayed or whatever, and you hit that 31st day, it would make no sense to say that the manufacturer has to completely buy a new car for that person. And so that would be our statement on that type of issue. And I don't think the statute says that. It says specifically a presumption. Make sure. Your Honors, if there's nothing further, okay.
All right. Well, I thank you both for your arguments. We are going to take a short recess to get the courtroom set for our next argument. We will take this matter under advisement and issue a written ruling in due course. We are at recess.